In a landmark decision, the U.S. Supreme Court ruled that all presidents have broad immunity, essentially a license to commit crimes as long as they're using the official powers of their office to do it.
The president now is absolutely immune, so free from any criminal prosecution within the core functions of that office, which include a lot of things.
This not only reshapes the presidency, it can reshape the entire functioning of American democracy.
The decision stems from that pending criminal case against former President Donald Trump, where he was indicted for an alleged attempt to overturn the 2020 election. In his defense, Trump argued he should be immune from anything he did as president, because he was president.
The president of the United States, and I'm not talking about myself, I'm talking about any president, has to have immunity.
He argued the Supreme Court should throw out this indictment entirely. They didn't do that, but their ruling will have a huge impact on what happens next.
The Supreme Court has absolutely taken a chainsaw to the most consequential case against Donald Trump, the January 6th case over his attempt to steal the 2020 election.
So what does that look like? Let's go through it. The heart of this case was a question that's never been tested by the Supreme Court until now. Are U.S. presidents immune from criminal prosecution? The decision was, for the most part, yes, but not entirely.
The court, in a rather complicated way, carved out various levels of immunity that a president might enjoy. I mean, they literally said a former president enjoys some immunity, which is of course not a very helpful term, but they then went on to try to define to which actions that immunity extends.
The Chief Justice broke things down into 3 distinct categories. Category 1 is where the president is totally immune. He can't be charged.
So we have core presidential functions. Those are absolutely immune.
Category 2 is where he's possibly immune, but not guaranteed.
Then we have implied presidential powers, and those are presumptively immune, but they could be rebutted by a prosecutor.
And category 3 is where he's not immune at all.
And the third category is private actions. So if it's an unofficial act, a private act, that can still be prosecuted.
Let's start with the first category. According to the court, a president should be absolutely immune from criminal prosecution when engaging in any kind of official acts that rely on core constitutional powers.
So really famous ones would be that the president is the commander-in-chief. That makes him have war powers. He also has a pardon power, and he can appoint judges and ambassadors.
If you or I authorized a drone strike, we'd go to jail for a long time, not the president.
The Chief Justice gave an example related to this case, the allegations that Trump directed his acting attorney general to investigate the results of a 2020 election. And this is a core part of the January 6th case against Trump, where the prosecution argues his conversations with the AG were an attempt to leverage the power of the Justice Department for his own political gain. But according to this Supreme Court decision, working with the Justice Department to decide which crimes to investigate falls directly within a president's core powers. And so they write, Trump is absolutely immune from prosecution for these acts.
So in Jack Smith's mind, the special prosecutor, that's all part of a criminal conspiracy. But what the Supreme Court did is they said that part of the criminal conspiracy cannot be considered by prosecutors or future jurors hearing such a case, because that falls under core presidential powers.
The court also decided when something falls into this category of core presidential powers, not only is the president immune from being prosecuted for that action, but that action itself can't be used as evidence to prove anything else either.
If you are trying to convict a former president, for instance, for conduct that was in fact outside of their official acts, but they, for instance, admitted that they were going to do it during a speech as part of their official capacity, the speech would not be allowed to go into evidence.
And that's an extra blow to prosecutors in this January 6th case, because all those conversations with the Attorney General are now off limits.
Jack Smith's indictment refers 51 times to these conversations. showing Trump was told repeatedly, again and again, that he'd lost the election, that he knew he lost and was trying to cheat. Now that evidence is gone.
This second category is where things get a lot murkier. Even the legal analysts we spoke to found it hard to interpret, so we'll do our best. According to the ruling, this category includes other official acts or interactions that fall within the outer perimeter of a president's official duties. So these are things that aren't 100% related to a president's core powers, but could be seen as an official act in some way, shape, or form. These actions, they ruled, require at least presumed immunity.
There's a large gray area of ambiguity that is a public work by the president, but doesn't fall neatly into core presidential duties, where essentially it's unclear whether conduct is going to be immune.
So what falls into this gray area? Well, in relation to the January 6th case, the Supreme Court argues it includes things like Trump talking to Vice President Mike Pence about stalling the election certification in Congress.
If Mike Pence does the right thing, we win the election.
The Chief Justice argues he believes these conversations did involve official conduct, and Trump is at least presumptively immune from prosecution for such conduct. But he also said Trump may still be liable, depending on the specific circumstances surrounding those actions.
So they place talks between the president and the attorney general off the table. That is a core presidential power in their mind. But they basically say that the pressure on Pence may fall into a different category.
Because Pence, in that circumstance, is acting as the head of the Senate, he's not part of the executive branch. And so I would have thought that there's a strong argument to say that that can't be part of the president's official acts. However, the opinion written by Chief Justice John Roberts suggests that it in fact would be considered an official act because it might affect their relationship in an ongoing way.
Other things that the court says may or may not fall into this category are things like Trump's public tweets and meetings with private groups. The final category the court laid out is the president's unofficial acts. For these, the court ruled there should be no immunity. So this includes crimes completely unrelated to the president's job. Say, if the president hit someone while driving drunk. But it could also include moments where the president is speaking in an unofficial capacity, as a candidate for office or as his party's leader.
One of the examples they gave of private behavior is campaigning. That is probably going to mean that most of the January 6th case against Trump will actually stand, because most of what he is doing in his private capacity as a candidate for president, not as the sitting president.
This means the January 6th prosecutors can and likely will argue that many of the things Trump is accused of doing, the ones that fall into that gray area, shouldn't be considered official conduct. That he was acting as candidate Trump, not as President Trump. But the onus is now on them to prove whether something is official or unofficial, and the legal bar is high.
They've remanded most of the case back to the district court to have Judge Chutkan determine whether or not what Trump is alleged to have done is official, in which case it would be immune for prosecution, or unofficial, in which case it could be prosecuted.
What the court majority does is erect a series of procedural barriers and hurdles that the special prosecutor, Jack Smith, would have to clear prior to pursuing any of the particular charges. And those would be fact-intensive inquiries, and the president or the former president would have the opportunity to challenge those inquiries.
The court has delayed the case. It has damaged the case, lopping off some of its evidence. And more than that, it has possibly destroyed the case, because there's virtually no chance now it'll get to trial this year.
It's important to note that this wasn't a unanimous decision. The justices voted 6-3 along ideological lines. And according to the 3 liberal justices, this decision changes everything. It creates an atextual, ahistorical, and unjustifiable immunity that puts the president above the law.
I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
Justice Sonia Sotomayor says this ruling isn't supported by the Constitution, by history, or even Trump's own lawyers based on past arguments. She argues there's no provision in the Constitution for presidential immunity. It does make way for some narrow immunities for legislators under free speech and debate in the House, but not presidents. And she says that's not an oversight by the writers of the Constitution, because some state constitutions written at the same time did give criminal immunities to sitting governors. So basically, they could have included it for the president, but chose not to.
The founding of America was literally the United States declaring its independence from the King of England. We didn't want a monarch. We specifically have a president who has limited powers, and even the president was not above the law. And this decision really changed that.
Because just think about what this kind of immunity for someone in this role could mean. Sotomayor asked what would happen to a president who organizes a military coup to hold on to power. Immune. Or takes a bribe in exchange for a pardon. Immune.
The liberal minority on the court, in its dissenting opinion, says you've created a dictator.
We've opened the door to things like a corrupt pardon or a pardon for money. Since the pardon power is a core power, that is completely immune under this decision. So that is a sort of king-like power. I mean, it really changed the way presidential power is going to be dealt with by the courts.
But the Supreme Court majority argues that this decision actually acts as protection for future presidents. They say a president can't do their job if they're concerned that every decision they make could inspire their rivals to charge them with a crime the second they leave office.
That's the majority's rationale, that the executive needs to have broad discretion to do the things that need to get done to run the country.
Now, for all the headlines about precedent setting and concerns about the future state of the presidency, and there are a lot, the immediate blow for Trump's opponents and critics is that this decision now all but guarantees that any semblance of a trial for his alleged actions on January 6th will not take place before November 5th. That's U.S. election night, after which former President Trump may in fact be President Trump, with all the new powers that now come with that job.